Hi everyone and welcome to This Week in 18C for February 25, 2017. I know I'm posting this on the 3rd of March. I was away last week, all of last weekend on a camp for university, so I couldn't do it then. But I am going back to the week ending last Saturday, and I'm going to do it do this episode for the week preceding that Saturday. So we don't have a whole lot to discuss from the week ending this past Saturday. Just two articles. The first one I'm going to look at is from The Guardian. It is from Monday, February 20, 2017. It's called Senate Inquiry into 18C Told Day-to-Day Racism Can Cause Physical Harm. And the article reads as follows. The Northern Territory's Anti-Discrimination Commissioner has warned that day-to-day racism could be causing physical harm to people and has rejected the renewed calls to wind back Australia's anti-discrimination laws. Now, 18C deals with people saying things that offend other people if they're said on the grounds of race. That's not physically harmful, right? It doesn't deal with violent assaults or anything. If they're talking about that racism can cause physical harm in the form of a violent, racially motivated assault, well, of course, no one thinks that should be illegal, and the plan to wind back 18C would not change any of that. But let's read on to find out what they do mean. The Attorney General, George Brandis, set up a parliamentary inquiry into possible amendments of Section 18C of the Racial Discrimination Act after a renewed push from Conservative members of Parliament. This section is a civil provision, not a criminal offence, true, and is aimed at protecting Australians from discrimination and vilification. That might have been the aim in 1995 when it was first passed, but since then, and completely foreseeably, and to the surprise of no one, a law that says it's illegal to offend people has now been used by people who never want to be offended so badly that they're willing to sue people over it to do just that, to sue people who offend them. So whatever the design was, it was written in a way that was never going to be limited to that design. It's gone way over the top. And we've seen the effects in the last couple of years with the QUT case and the Bill Leak case. The Bill Leak complaint didn't actually go to a trial or anything. And the Japanese War Memorial complaint, and complaints like these are emboldened by laws that say it's illegal to offend people, even if the intention is only to protect from vilification and discrimination. There have been a high volume of submissions to the inquiry, with a number outlining concerns about changing the legislation. A particular focus of the inquiry has been whether to amend the Act so that speech that offends or insults cannot be captured by it. There are already broad exceptions for media and public commentary. So you can tell that The Guardian is against changing 18C. I made this point in the last video, and I'll continue to make the same point where necessary throughout these episodes. So Section 18D, the free speech exemption section, requires that speech that is going to be exempted be done reasonably and in good faith. If you don't know the law very well, that sounds perfectly fine, but in reality, reasonably and in good faith is a very high bar to meet. It means you have to have said what you've said with a tone that is not too offensive, and you have to go to a lot of effort to make sure that it doesn't come across as particularly harsh or anything. You can't use adjectives that are too pointed, or you can't be too funny, and you have to be in the style of, I personally think that it's a bit too much of this, but on the other hand, there's still... And you get the idea. You have to dumb down and water down your point a lot in order to be exempted by 18D. In the Andrew Bolt case, Andrew was found to have breached the Act and not been eligible for an 18D exemption because, in the words of the judge, partly because he used, quote, inflammatory and provocative language, unquote. The article continues. Commissioner Sally Sievers outlined the severe problems with racism and discrimination she heard from members of the Northern Territory community and reiterated that changing the legislation would be detrimental to the community. She quoted from international research in the US on the health impacts of racism. Okay, here we go. We know about that experience and it is accepted that it impacts on people's mental health, she said. But we're also finding out that it can have physical symptoms. The medical research is saying that this day-to-day experience of racism is making these groups sick. Okay, so they're not talking about violent assaults, which is good, because they would have been completely irrelevant if they were. I'm not familiar with the research that says racism is making people physically sick. I know full well it makes people mentally ill, but physical sickness, I'm not sure. And the other issue is, while it's of course a terrible, terrible outcome wherever that's coming true, she is not defining exactly what these people who are feeling physically sick are being subjected to. Are they reading things in the media they don't like, or are they being personally face to face abused because of their race? Now, if it's the latter, that is a big problem, and that should remain illegal. And I wouldn't support a change to 18C that would make personally abusing someone face to face illegal. Legal. But if all that's happening is they're being offended by things that they're reading in the media, and that's having a cumulative effect, I guess, where it makes them feel physically ill. Of course, I don't want that for them, but the much better solution is for them to not read it. The article goes on. She said she was not aware of any similar local study that had been conducted. She also questioned whether changes should be made to the Australian Human Rights Commission's complaint handling processes. What we do know is that very few people do actually complain, she said. It's really important from our perspective that we don't make the process of making a complaint harder. She urged the committee to think incredibly carefully before you put further barriers on allowing people to complain. This is completely false. It is very, very easy to complain to the Human Rights Commission. If you have been offended because of your race, you can complain. Now, the fact that you can complain doesn't mean you're automatically going to find the person who you allege offended you guilty of doing an illegal act, right? There might be some barriers to being able to find them guilty, but there should be those barriers. In a free country, we're not supposed to find people guilty of illegal acts on the basis of accusations alone. The article says next, when asked about the appropriateness of the words offend, insult or offend in the act, she responded, in relation to the phrase is seen as a whole. It's offend, humiliate. In the way that phrase has been interpreted, they haven't pulled them out to be interpreted on their own. No, that's completely wrong. Under 18C, an act is illegal if it's done because of someone's race, which in practice means talking about racial issues, not just singling people out for their race, and if it is reasonably likely in all the circumstances to offend, insult, humiliate, or intimidate some or all of a group of people. Not and intimidate, or intimidate. One of those four categories is sufficient for the law to have been broken. It does not need to breach all four. It does not need to be offending and insulting and humiliating and intimidating. She's either lying or she's got her facts completely wrong. The article continues. She pointed out that the word offend appeared in the range of offences across the country. Yes, it does. We have a lot of stupid laws that make offending people in some way illegal, and those laws should be repealed too. She said it was settled law that only most serious conduct had attracted the provisions under the Act, but warned that if it was amended, it would create further legal uncertainty. If you start mucking around with it, you're going to end up with another 20 years of judges and lawyers talking about what the new phrase means, she said. You won't if you define it specifically. There's a very easy solution to that problem. Parliament, make sure you have specific definitions of any new terms you put in. Done. Daniel Woodruff, the Principal Legal Officer at the North Australian Aboriginal Justice Agency, said that the refusal of services was the most substantial issue facing Indigenous Australians. Now, that is actually something genuine to be worried about when it comes to racism. 18C does not cover, or does not concern itself with refusal of services, right? It concerns itself with doing anything that offends someone, right? You change 18C, there are still other laws that make it illegal to refuse service to someone because of their race. 18C is not going to weaken that at all. That is a legitimate problem, but he's missed the point of what is going to. If he's worried about that becoming legal, refusing services, or not being dealt with harsh enough, he's in the wrong place if he's focusing on 18C. John Rawnsley from the Aboriginal Peak Organisations of the Northern Territory outlined the impact that amending racial discrimination laws could have amid the broader context of loss and trauma experienced in the Territory. There's significant loss that's been experienced across the Territory, he said. When we send a message in terms of watering down protections for racial discrimination, it feeds into that historical narrative. Okay, we have to get something here, and we have to get it clear now. There is absolutely no similarity between changing 18C and the Stolen Generation, or the Mile Creek Massacre, or Section 127 of the Constitution. Right? These were, systemic institutional forces that imposed racism on Aboriginal people that did tremendous harm. Saying we do not believe it is serious enough to get the government involved if someone is offended is not like that in the slightest. Even if some Aborigines think they do, and I would guess that the number of Aborigines who think it is similar is much lower than this guy thinks it is, that still does not make them correct, right? They might think it, I don't want that for them. I don't want them to think that they're being treated like they were historically if 18C is changed. But nonetheless, we can't let their misperceptions about what it would mean to change 18C dictate changes to 18C or stop changes to 18C, right? The article is now getting to its end. Amnesty International, academics, and the Journalists Union have warned that laws restricting information about national security and immigration detention are a greater threat to freedom than race speech laws. I agree with this, right? And I do think that these laws, like Section 42 of the Border Force Act, for instance, is a bigger threat to free speech than 18C. The reason I talk about 18C more is because most people agree with me about Section 42, but the government passed Section 42 of the Border Force Act, I believe, in October 2015. It's not going to be repealed anytime soon, regrettably. So me adding my small voice to Section 42 is not going to do much. But also with 18C, opinion on changing 18C is split roughly 50-50. There are more Australians in favour of changing it than not, but I think it's tenuous support. I'm worried it could recede, and it's only a small amount of support over not changing it if it does hold steady. So I want to try to give people the evidence and arguments that explain why 18C should be changed, so I can convince them more solidly in their minds why it should be changed. That doesn't need to happen with Section 42 of the Border Force Act. I'll now move on to the second article. This article was published in the ABC on February 20, 2017, and it's called Racial Discrimination Act. NT Aboriginal Communities Not United on Changes to Section 18C, Inquiry Hears. And here's how it goes. Aboriginal communities in the Northern Territory are not in agreement on whether Section 18C of the Racial Discrimination Act should be changed, a federal inquiry has heard. The Parliamentary Joint Committee on Human Rights was in Darwin on Monday to hear submissions on the potential changes, including to remove the words of insult, offend, and humiliate from the section. But in Aboriginal communities, there is not a consistent opinion on the proposed changes, said David Woodruff, President Legal Officer at the North Australian Aboriginal Justice Agency, the same guy who was mentioned in the Guardian report. We recognise there's no one common position in the NT Aboriginal community, and we respect the other individual opinions, he said. But as a representative of NAAJA, Mr. Woodruff said his opinion was that changing the Act would send the wrong message. There's at least a consistency in relation to the opinions of NAAJA and APONT, which is the Aboriginal Peak Organisations of the Northern Territory, and other legal services, in respect of our client that there is no need for change, he said. Now, what I like about this article is that it includes that quote from him, acknowledging that not all Aboriginal people, in fact, agree with keeping 18C the way it is, the way the Guardian kind of implied that they are. The Guardian omitted that quote about him acknowledging there being diversity of opinion among Aboriginal people on this subject. But I do have one comment about when he says, in respect of our clients, there's no need for change. This guy's from a legal service. Is it really a good use of resources for legal services to be obsessed about cases where someone's been offended? There are plenty of cases, of legal cases in Aboriginal communities where they do need legal assistance on matters much, much more urgent than this. Much, much more urgent than being offended. I think he and his organisation have their priorities wrong by focusing their resources on keeping 18C, and I guess it looks like on pursuing 18C cases if they ever come across a potential case. He then finishes his part in the article with this comment. There is need to send a positive message for the protections to continue rather than causing divisions. This is just bland rhetorical platitude, so there's not a whole lot I can say about it, other than why the assumption that it is a positive message to send that offending someone because of their race should be illegal, and what division is going to be caused by repealing it. In my mind, 18C is causing division because it makes some non-Aboriginal people resent Aboriginal people, which I think is really, really sad. But those people do it anyway because they think that Aboriginal people have special rights and they think that Aboriginal people are censoring their freedom of speech. That's going to cause division. That's going to cause resentment. I think that's deeply regrettable and certainly not what I adhere to. But realistically speaking, that is what happens. So if you want to get rid of division, I would suggest scrapping 18C. The next part of the article, the ABC cites a comment of Kevin Kadiagama from the Northern Territory Multicultural Council. He's the president of that council, and this part of the article reads like this. Changing the Act would be a backward step, NT Multicultural Council President Kevin Kadiagama said. What we fear is that a watering down could mean that people who are victimised could be sidelined, segregated, not feel part of the Australian society. That leads to extremism, he said. That is a root cause of extremism that has not been addressed adequately. Okay, now, there are various exact, specific instances of offensive speech that you could be referring to here that could cause extremism. Now, here's what I will say. If speech is genuinely bigoted and prejudiced, then that's of course wrong. And I do agree that, regrettable as it is going to have an effect on some people of making them feel not part of Australian society. That's just reality. So for that reason, I urge people not to be bigots, but also for the reason that it's wrong to be a bigot. But if he's talking about speech that is a legitimate commentary on a social issue that someone in a certain demographic is offended by or disagrees with, and that makes them feel marginalised to the point where they become extremists, the problem is not what was said. The problem is that they have reacted in a bad and stupid way, right? So, when some people who criticise multiculturalism have criticised it on the grounds that in order to maintain social cohesion, we've had to end up sacrificing freedom of speech. This guy has inadvertently conceded their point on this and conceded that their point is applicable in this instance, right? If it is necessary that other people shut up and don't say offensive things lest someone else will be radicalised into extremism, then we have lost our freedom of speech in order to maintain community cohesion. I'd also suggest that if someone is so sensitive and their beliefs about whatever are such that merely encountering something offensive is enough to radicalise them into extremism, then they were in a bad spot in the first place. And their mindset that took them down the path into extremism, where they were radicalised just by being offended, that needs to be changed. And that needs to be challenged, and they need to be brought out of that mindset, right? We can't get them out of that mindset if it is illegal to talk about it because they might get offended, right? Now, I actually would prefer us to keep our freedom of speech and keep our liberty, and I think that is worth a few more people getting radicalised if that is the case. If it is indeed the case that some people get radicalised by what will be said that I think should be legal if 18C is repealed, that is a price I'm willing to pay. I'm not willing to say in the face of a threat like radicalisation, we're going to throw away our freedom for it. We're going to, basically say, you win, we're going to submit to you and sacrifice our freedom so you don't kill us. No, I want to stand up to radicalisation and extremism, and I don't want to sacrifice liberty for it. The rest of the article cites Alice Springs Town Councillor Jacinta Price, who supports changes to Section 18C and disagrees with the silly, hyperbolic apocalyptic rhetoric about what's going to happen if we change it. So I strongly recommend checking what she has to say out. I won't respond to it here because I largely agree with it, so there's not much to respond to. But definitely check it out. I'll link to the article in the description. You can have a look. So thanks for watching this episode, and I'll see you tomorrow because tomorrow is Saturday, and I'll do week 3 tomorrow, and obviously this week was later. So see you tomorrow.